Good morning, everybody. Can you all hear me? Yes. Okay. Good morning, everyone. So my name is Ais Tusela, and I'll be moderating this panel. This panel will be conducted in English and Portuguese. We have a Portuguese guest. Is it okay? Okay. Apparently there's an echo. Try to move the mic further. Is it okay now? So you will see that you have some headsets next to you, and if you don't have any, just raise your hand and we can get one for you. And so is it possible to give them some headsets? Thank you. And there's somebody here as well that doesn't have one. So if you need to have a translation from English to Portuguese, press 1, and or select 1. And if you need to have the translation from Portuguese into English, then it's 2. So thank you very much for joining us for this panel. This panel is about convergence and regional and global cooperation between data protection authorities. And I have the pleasure to have a distinguished panel. And I will start with somebody who couldn't join us today physically, but she's here online from Mauritius. And this is Mrs. Rudisha Madhub, the Data Protection Commissioner of the Data Protection Office of Mauritius, and she has held this position since 2007, so she'll have loads of things to discuss about and experience. And before she was the Data Protection Commissioner, she was the Senior State Counsel at the Attorney General's Office for more than 6 years in Mauritius. Good morning, Rudisha.
Glad to be with you today. My real pleasure.
Thank you, Rudisha. And the second panelist that we have is here on my right is Tamar Kaldani, and she's the Vice Chair of the Consultative Committee of the Council of Europe Convention 108, and she is also the former Data Protection Supervisor of Georgia. She held that position from 2013 to mid-2019. Good morning, Tamar. And the third one, further on my right, is Mr. Valdemar Gonçalves Ortuño Jr. He's the President Director / Chief Executive of the Data Protection National Authority of Brazil. He took this position in 2020 and has a 6-year term. So his input would be great in terms of expectations as a newly appointed and a new data protection authority, newly formed data protection authority. And last but not least, hello. last but not least, we have Joaquin Perez Catalan, who's the Director of the International Relations Division of the Spanish Data Protection Agency. And he's a trained and qualified engineer and has more than 25 years experience in the fields of security, data protection, privacy in Spain and abroad. Good morning.
Good morning.
Just so you know, towards the end of the panel, we might get an intervention from Colonel David Kanamugire, who's the CEO of the Cybersecurity Authority in Rwanda, and I'll introduce him further at that time. So we are going to start talking about convergence and collaboration and cooperation between data protection authorities. And I'm going to ask my first question to our Brazilian Data Protection Commissioner. And so to you, Valdemar, My first question is, as a quite recently created authority, what is your expectations in terms of cooperation between data protection authorities?
Bom dia a todos. Inicialmente, eu gostaria de cumprimentar a organização do evento. Achamos muito importante discutir o tema de privacidade de dados a nível, principalmente, mundial. Cumprimentar nossos painelistas e trazer uma boa notícia que o Brasil também entrou na área de proteção de dados. Vimos a necessidade do assunto, a importância. Nossa Lei Geral de Proteção de Dados, ela é bastante inspirada na lei europeia. Nós tivemos 8 anos de discussão no Congresso para se aprovar essa nossa lei. Foi aprovada em 2018, entrou em vigor em 2020. A Autoridade Nacional de Proteção de Dados também foi criada no ano de 2020, mais especificamente dia 6 de novembro. E no Brasil, normalmente, um órgão ele vem de uma evolução. Ele é uma diretoria pequena, vai crescendo, se transforma numa secretaria até chegar a uma estrutura maior como órgão. No caso de autoridade, foi totalmente diferente para o Brasil. Estávamos na pandemia, então não se queria desviar atenção e recursos focados para um tema extremamente importante. Então, a autoridade ela foi criada do nada, sem direito a aumento de despesas para o governo. E foi um momento oportuno, não se devia realmente esperar passar a fase para a criação da autoridade, tendo em vista a importância do tema, tendo em vista a burocracia de uma série de medidas necessárias. Então, nós fomos inseridos em 5 diretores, no primeiro momento. Hoje já contamos com um grupo de colaboradores de 67 pessoas. E extremamente importante, nós temos a nossa autonomia técnica e decisória. Então, todos os diretores têm mandatos, como é a primeira diretoria, de 2 a 6 anos. Isto nos dá uma independência muito grande, faltando a independência orçamentária. É muito importante estar ligado à presidência, porque nós tivemos a modalidade de requisição. Então, foi onde iniciou nossa colaboração. Nas diversas agências reguladoras brasileiras, nós pudemos buscar, entrevistar e selecionar pessoas habilitadas e capacitadas na área de interesse da autoridade. Por exemplo, na área de fiscalização, normatização. Com isso, nós criamos rapidamente um time com bastante expertise, já em cada um em sua área, e entramos rapidamente em produção. Aprovamos nosso regimento interno, nosso plano estratégico, nossa agenda regulatória, e começamos a atuar de uma forma rápida, porque, vamos dizer, parecia que o mercado brasileiro estava esperando a criação da NPD para começar a divulgar mega vazamentos. Então, isso já começou a acontecer de uma forma intensa, e nós tínhamos que dar uma resposta à sociedade. Então, esta foi a nossa rápida história. Temos 1 ano e meio, mas já com uma entrega considerável. A gente tem recebido retorno dos diversos setores, e isto, vamos dizer, nos dá um grande orgulho pela rápida atuação, rápida adequação ao nosso cenário nacional. Conseguimos isso de que forma? Justamente através dessa colaboração. A colaboração interna das diversas agências que entendiam que era o momento da Autoridade Nacional de Proteção de Dados. Então, nós não tivemos grandes obstáculos para buscar as pessoas, buscar sistemas, buscar soluções, até insucessos nós pudemos contar para não cometer os mesmos insucessos de outras agências reguladoras, e na área internacional o mesmo. Na Europa nós ganhamos, logo no primeiro mês, uma capacitação para autoridades, colocamos todo o nosso time nessa capacitação. Com a agência espanhola, nós firmamos um acordo que foi extremamente frutífero, diversas experiências nos foram passadas, sistemas disponibilizados. Então, já quero agradecer a Espanha por essa colaboração inicial que nós tivemos. É extremamente importante para quem está começando ter esse compartilhamento de experiências e não repetir erros, e repetir os mesmos sucessos. São fatos.
Reiterate success stories. This is of such importance. And something else. The national authority put together an advisory board that is made of 23 officers and 23 other staff. So this ends up collecting a number of representatives from the judiciary system, from the academia, from the private and public sectors, from associations, labor associations, and this has been of great assistance in allowing us to offer various consultative products and services. The goal is to, in a very short time, present to the country national policy for the nation. So this is just a bit of our first months, precisely a year and a half of our story. We had a number of struggles, but also equal number of successes. Thank you.
Thank you very much, Valdemar. Thank you. So it's very interesting to see that given the size of the country, you're scaling up in terms of capacity of the authority, and also in terms of what you have done regarding cooperation with other data protection authorities. You had the help from Spain for capacity building and getting the lessons learned from them. So thank you very much. That's really interesting. And I think this is in line with what we will be talking about regarding the other questions. So talking about lessons learned, we have some panelists that have been in data protection authorities for a long time, or used to be in data protection authorities for a long time. And I was wondering, what's your, from your experience, what have been the key benefits of international cooperations between data protection authorities, if you have some specific examples, and then what are the challenges that you have identified? And for this, I will start with Tamar in her capacity as a former Georgian DPA chair, and also later on as a member of the COE Convention 108.
Thank you. Thank you so much. Good morning. Let me start by saying how delighted I am to be part of this panel, and secondly, I would express my appreciation to organizers, European Commission, for bringing data protection authorities from different parts of the world and with diverse experiences and models to discuss not only the benefits and future opportunities for international collaboration, but how by joining their forces, data protection authorities can contribute to the convergence between regulatory systems. When data flows have no geographic boundaries, then national and regional solutions are important but not sufficient. And as the first data protection commissioner for Georgia with very little or no leverage over the multinational companies. I had to deal with a number of cases where I had to use international cooperation platforms and even bilateral formats to ensure at least some remedies for the individuals affected. And I would be honest with you, we were not always successful in our endeavors because due to the number of reasons, including differences in legal systems, not having in particular jurisdiction a partner data protection authority, or like limited abilities to get information on time or conduct joint investigations with other regulators. At the same time, Georgian Data Protection Authority is privileged to be a part of many networks. First, just established in 2013, we joined the TPD, the Consultative Committee of the Council of Europe Convention 108, and I cannot fully express the gratitude for the support we received from the Council of Europe, but also from the EU commissioned technical assistance and cooperation projects in advancing our legal framework, bringing them closer to European standards, building our capacity. And it was very important because from 2013 to 2019, when I was commissioner, we were part of visa liberalization process, association agreement, and generally all those projects helped a lot in our European integration. Then we joined Central and Eastern European Data Protection Authority Network, Spring Conference, International Conference, Berlin Group, GPAN, which is Global Privacy Enforcement Network. We were part of case handling workshops, and many groundbreaking and standard-setting decisions that we were making at the national level were inspired by best practices of more experienced data protection authorities, recommendations and guidelines of the Council of Europe, Article 29 Working Party, now EDPB. And those platforms helped us to be part of meaningful discussions, policy making, and also helped us to build bilateral collaborations. And I would just use this opportunity to warmly thank Polish, Italian, Belgian, German, UK DPAs who hosted or visited us to share their experiences. And after a few years, we were in a position to host the annual meeting of Central and Eastern European DPA Spring Conference, and also host other delegations from Ukraine, Moldova, Central Asia. And we have been putting labor of love in those meetings, not because hospitality is in our DNA, but because we were supported by others without forgetting. And I think this is very important. To conclude, I would say that international cooperation between DPAs has long been essential and is even critical now. When we see that number of data protection laws worldwide, as Professor Greenleaf was telling us yesterday, reached 157, and there are 20 plus bills under negotiations. And many of those acts and bills follow the principles and approaches founded in Council of Europe instruments, OECD instruments, and more importantly, GDPR, which really raised the bar for privacy rights globally, is reference point for many legislators, and for me it's especially important. It became a catalyst of strengthened oversight and supervision. So these positive developments opened a new window of opportunity, definitely, for convergence, and data protection authorities can certainly play a very important role in this process. Thank you.
Thank you very much, Tamar. That was very interesting to hear that you more or less started from nothing and just looked around and managed to get the help you needed around. So I suppose they had to be quite proactive in seeking those networks and seeing what they could be useful for. Okay, thank you. So I will ask the same question now to Rudisha in Mauritius.
A mesma pergunta para Rudisha in Mauritius.
Yes, thank you, Setu. I think I have a lot to say. Can I speak? Because I can hear an
Yeah, we hear you.
Okay, thank you. So I have a lot to say on all the networks. Definitely, I would start by the Mauritian success story. I think it's very important that I make it, from a geographical perspective. Mauritius is an island, and it's quite segregated and excluded, between inverted commas, from the rest of the world, even from Africa. And it was really difficult for me when I started the office to be able to make it a meaningful and efficient institution right from the start. There was a lot of struggle. But the main success stories for Mauritius have been that we were the first non-European country which ratified Convention 108 plus, and the first African country after for Convention 108 as well. So this has been a long journey since 2016 for us, since we ratified Convention 108 and subsequently Convention 108 plus. We are also the first country in Africa which aligned its Data Protection Act in 2017 with the essential principles contained in the GDPR and Convention 108 plus, because we wanted to be proactive instead of relying on already outdated EU directives and documents and instruments. We tried to adopt Convention 108 plus in our legislation of 2017, and in January 2018 the law was passed, and since 2018 we're implementing these novel principles in the Mauritian context. So these were the two important aspects I wanted to mention about Mauritius. But as any other data protection authority, we always struggle. We always have challenges in terms of resources, finance, approvals from administration. Even if we are independent in nature and in substance, we do not, no one interferes with my functions, but still, administratively, we have so many linkages to our parent ministry and to the rest of the government. But the good thing also is that we submit an annual report to the National Parliament here, which highlights all that have been done throughout the year by the Data Protection Office. And then, there is this dialogue with Parliament and the committees under the parliamentary system, where we can actually bring our representations. So this is a fair picture of Mauritius. There's a lot to say about what has been for the past 15 years, but definitely not within the purview of this discussion today. So I would now seriously move to networking. I think networking is really at the heart of international cooperation. Without networks, for the past, let's say, 40 years, or even more, the data protection has been a lively feature worldwide. I don't think it would have been possible for data protection authorities and data protection itself to innovate and to modernize the principles internationally. So networking is essential. A lot has been achieved, as Tamara stated, bilaterally, regionally, and internationally through networking and through discussions. However, the question that I have, and I think the audience also would like to know, is, do these networks still meet current requirements? Should they be revisited? What type of synergy, should exist between the different networks? Some of them are geographical, some of them are international. So what type of synergy do we require between these networks? Has there been a proliferation of networks beyond measure? Too many networks as well.
Rudisha, sorry to interrupt you on this one. We'll cover this for the next question, if you don't mind.
I will not be answering all of them. Okay. But what I want to say is that from being a member of these different networks, I think these are the questions that I would like to hear also from other members, and I also have my input. But what I've seen, let's say from the NADPA perspective, GPA, APDP perspectives, is that we all have the same mandate, right? We all have the same type of functions, objectives, and mission. But being given that we all have the same, do we really need this duplication, in terms of function? Let me now just put another aspect to this debate, is definitely we're all striving to bring international solutions to our global problems, right? But we don't have an international specialized framework yet on data protection where we can actually inspire ourselves. We have a GDPR, we have Convention 108, but we all know that we don't have a global instrument as such. And we are looking forward to have this type of instrument to be able to, really parameter what are the different functions that are required from the networks, for example. And one more important aspect that I would like to say before I stop here is that if you look at the membership of networks, let's say data protection regulators mostly, but what is really lacking is that we don't have expertise outside data protection authorities. We don't have, let's say, academia being really in focus. We don't have private experts, etc., which form part of these networks. So officially, the membership is, I would say, quite restricted. We need to really think about networks now going beyond data protection authorities and regulators so that we can have, meaningful networks. So I would stop here, Asitu, and definitely will come back to what you told me just right now. Thank you so much.
Thank you very much, Rudisha. That's very interesting, and it's a very interesting point that you raised regarding not only the fact that we have many networks, but what are they made of? Do we need to only have DPAs talking between themselves, or do we also need to have representatives of different stakeholders and some experts? So that's a very interesting point here. And so I will move now to Joaquin Perez Catalan from Spain, who could also share his experience.
Good morning, and thank you. Well, I would like to start my presentation, say thank you to the organization and also to the European Commission for giving me the opportunity to be here with all of you. Well, about collaboration between Data Protection Authority, I have to say that when I see to the past, I had to remember when I started working at the Spanish Data Protection Authority in 1994, in the last century. So a lot of years happened. We started at the beginning making collaboration with some European countries that are around us, because we were members of the Schengen system, and the first initiative of collaboration came from the Schengen system. We had to implement it audit in the common system of Europe, and this meant at that time to create audit teams from different countries, and we had to collaborate to participate hand by hand, making inspection and audit in the central system of the Schengen system. No? This was a very, very good experience at that time. I think for me it was the first experience of collaboration with other authorities. But it was only the starter. Later on, the European Commission launched twinning projects. That was a program in order to facilitate the process of becoming part of the European Union from the countries that wanted to become part of the European Union. And my office has a very active position on that. We make a twinning project with different countries, EU countries at that time, with the Czech Republic, with Croatia, with Bulgaria. I myself was living 1 year in Bulgaria in one twinning project of that. Later on with countries that are not part of the European Union, like for example Israel. I was living also 2 years in Israel, collaborated with the Data Protection Authority of Israel, try to spread the culture of data protection through the country. And so we have a lot of experience on that area. That was in the framework of the directive. That also was a legislation that pushed to the Data Protection Authority in Europe to collaborate between the data protection authorities in EU. And we also interchanged information at that time in cases in which we need, for example, handling complaints, we need information from companies that were based in other countries of the European Union. And thank you to the directive, we had the opportunity to request information and to collaborate with other data protection authority. But at that time, the collaboration was at a very high level, because there was only in a few cases we have this kind of collaboration and interchange of information in the complaint handling. I think the good collaboration, the best collaboration started after the GDPR get into force, because under the model of the GDPR, the collaboration became more stronger and stronger, because we had to share the information. One of the revolution of the GDPR is in transborder cases that affecting more than one country in the European Union. There will be, at the end of the case, there will be only one statement for the cases. So it's not one statement for every country participating in the cases. It's only one statement, a final solution, a final decision for a transborder case. No? This means that the collaboration has to be very, very strong under the GDPR. Well, I am here because I have two hats. I have been talking about one of the hat coming from the European Union, because Spain is a EU country. But we have also another very important hat that I would like to talk with you, also with experience in collaboration. We are a Spanish DPA, we are the permanent secretariat of the Ibero-American Network of Data Protection Authority. This network was founded by a former director of the Spanish Data Protection Authority 20 years ago. So 20 years ago, we founded this network of data protection in Ibero-America. We have very good connection, jointly with Portuguese authority, with Ibero-America, from countries in the north, like Mexico, well, even in US. Many cities in US has a Spanish name. Los Angeles, San Francisco, California. So we have a lot of connection with America. So from the north, from Mexico to the south, to Chile, Argentina, with Brazil, they have more connection with Portuguese, obviously, but we have a very, very strong connection with American countries. 20 years ago, we created this network. At that time, there wasn't any, I don't remember any data protection authority working in America. There were only people mainly coming from the academia, some civil servants or important public administration in America. But during those 20 years, many data protection appeared in America. Even in very strong countries like Mexico, Argentina, Colombia, Uruguay, Costa Rica, Panama, and recently Brazil is, I think, one of the more powerful countries in America in terms of population and economy, and so we are very happy with the recent approval of the starting of the Brazilian Data Protection Authority. In the framework of the Ibero-American Network, we have tried to facilitate the collaboration among all the data protection authorities in the area. In that way, Spain is working as a bridge between the GDPR network of data protection authority in Europe and the American network of data protection authority in America. We have created different instruments in order to facilitate the collaboration, in order to focus and to get convergence between the authorities in America. For example, one of the instruments we have created in the network is the standards, in order to facilitate when one country of America wanted to create a data protection law. They had to, it will be easier for them just to take the standard and not to create a law from a paper in black, yeah? Just to use the standards. In that way, the different legislation in American countries has something in common. Because in the European model, we have the GDPR. This is previous to the GDPR, we have the directive. But in the situation in America is completely different. They don't have any structure that we have in Europe. It's a model completely different. In Europe, we have a design, we could say, top-down. We have a law that's in the top, and all the countries has to follow this law, and it's mandatory, the collaboration. But the situation in America is completely different. The design is, we could say, bottom up. So it's the initiative of the Data Protection Authority that wanted to participate and collaborate with the other one. And these have many different, many important implications. No? So different models, but I don't want to say what is better or not. This is not a question. The question is how to get collaboration in different models. No? But we have created those standards. Recently, we have approved in the framework of the Ibero-American network a set of contractual clauses for facilitate the international transfer. And I have to say that also we have a very good collaboration and support of the European Commission in this issue. And also we want to the collaboration of the European Commission, and I am happy to say that they are facilitating us support, economic resources, and so for the collaboration. And when I see to the past, I say, okay, we have doing a lot of things. But when I see to the future, I say, oh my God, we have a lot of things pending to do. No? So this is the lesson learned. We have made a lot of things, but we have many things to do. Yeah. Thank you.
Thank you. Thank you very much, Joachim. It's very interesting. Your perspective is very interesting because you are part of the EU, obviously as the Spanish Data Protection Authority, and also to the initiative to create the Ibero-American network, including North America, including the United States, Central America, and South America, and we've seen the benefit it has had for Brazil, and I'm sure it continue to have for Brazil and many other South American countries. And at the same time, you are also benefiting from the EU expertise and all the resources, so that creates quite a nice ecosystem. So thank you very much all for your answers. And coming back to what Rudisha was talking about initially, and it's the question of how to rationalize the networks we have, especially for countries. If you put yourself in the shoes of Tamar when she started, there were many different networks, and now there are even more networks than before. How do we make sure that with all this multiplication of networks that all have their use, we, first of all, we are aware that they exist if we're a new data protection authority. Second, that there is no overlap between what they do. And also, what do you think, how do you think those networks should interact, or how do you think the DPAs should interact with those networks? Should there be a network of networks, or should there be just a free movement between networks in accordance to the preferences of the DPA? So the first question will be to Valdemar from Brazil.
Protection date area, it's a great challenge. And we believe that alone our journey would be very, very hard. So the establishing of this network are extremely important, especially for the authorities new and the ones that are formatting. We are always seeking international synergies as an observance. We participate in the Convention 108. We understand about the networks in the Inter-American, and we are looking even more to get close to the networks and the international authorities. This facilitates our work a lot. We have framework, regulatory framework, and in 2021, we understand our objectives, and we have very important objectives to reach into 2022. We have many complex data, which is very complex in Brazil, which is the transfer of international data in Brazil. And our day-to-day, we are trying to reach rules when we are researching a lot to find knowledge. We are consulting specialists to understand. We are going to find out the opinion of several sectors in society, and even the citizens. We are looking into transfer of data in international. We have all this in our site. Everything is transparent. We have a lot of questions that come from the public, that comes from other sectors. And we are trying to get more specialized and understand even better how we could deal with data protection. So we have a huge number of material to work and to put it together. So this is a phase for preparation. We have public consultation. We have regulatory impact that we are analyzing. We have a council of directors that analyzing all this information. So this phase, it's towards gathering all the information, having an open dialogue with the several networks, so we can understand the diversity of this network. So, and in Brazil, it's very important to understand this diversity, and we are being able to accelerate our process thanks to this knowledge, thanks to this network, because these networks are feeding us with information. And we, for example, in February this year, the data protection started to be part of our constitution. We have an amendment by our Senate. So everyone voted in favor of this amendment, and this was a huge drive for Brazil. And we have no one opposing anything about data protection. So in our Constitution, Article 5, we have very explicit the need for data protection. And another very important factor for us is that the way that we are going to normalize, we're going to interpret how we are going to put it into law, this data protection. We understand that we are not going to create anything unless we bring it together, this dialogue. So this makes us feel a little bit more comfortable, because this will be put into law and makes our expectations higher to get where we want to get, which is to be independent, completely independent in terms of regulating our data. And it's something that we are fighting for, and then soon we will have everything. Perhaps this month or next month we would have this infrastructure for a scenery of data protection in Brazil, which is a big achievement, and we would like to thank the global scenery who are looking after this theme, which is very important for everybody. Thank you very much.
Thank you very much, Valdemar. And this is, from what I understand, it'd be really useful to have a very good mapping of all the networks at the outset for newly formed data protection authorities, because you see the value in having them. So thank you very much. And I'll move now to Rudisha, who, as she pointed out, is from Mauritius, which is an island kind of insulated by nature and part of different networks. I understand that the Mauritian Authority is part of the Network of African Data Protection Authorities, network of the Network of the Francophone Data Protection Authorities as well. And also, obviously, part of Convention 108 Plus now. So, Rudisha, from your point of view, and adding on to what you said that was very relevant, what would you say regarding the multiplication of networks and how that could be rationalized?
Thanks again. I think, just to highlight, that international cooperation is one of my main functions provided in our law, in the Data Protection Act. I have the obligation to internationally cooperate because every breach of our Data Protection Act amounts to an offense. So if I'm not internationally cooperating, I'm actually committing an offense. That is quite, it looks very funny, but this is the case. This is how our law functions. So I have a duty, obligation to internationally cooperate. That's why we make the initiative, we take the initiative of being a member of many networks as possible to be able to cooperate, even including joint investigations. This being said, I must also highlight, from my own perspective, I've been in networks since their inceptions, and we've been through a very long journey together in many networks. As I pointed out, I think having the same mandate in all networks is probably now. Maybe when we started, it was favoring a common cause. But now, actually, I think we have to move one step forward. That is, we have achieved that purpose that we wanted to have. Now, what is it next for networks? I have the feeling, to be very honest, that sometimes in some networks, it's like cooperation is competition. To be very honest, we don't want that in networks. We want networks who have, who are going to really support and facilitate the tasks that we have on table right now. That is, how do we collaborate on making a national authority more efficient in terms, of guiding principles? How do we help them financially? Why not? How do we help them in terms of resources? These are aspects that are still not really possible at the time. Maybe we have colleagues like my other colleagues stated, going on a mission and seeing how things are working on ground and giving some practical advice. It's very good. But we need more collaboration in terms of having, people working together through different offices across the world. Let's say the Mauritian Data Protection Authority is sending some resources to XYZ country in Africa. And then, we collaborate and we work and we make the institution work. I think these are things we have to study. But if you look at the mandate right now of these networks, you won't see anything. Support is very broad. Facilitation, sharing of knowledge is very broad. I think we have to put some more elements of specificity in the mandates to say exactly what we want now to achieve on ground for very practical reasons. Because investigations, like at our level, is criminal in nature and it's confidential in nature. We cannot really involve other parties. But what are, the steps that we can actually work together to make these investigations also a reality? This is one aspect I wanted to talk about, but if you will really allow me, I think, I have just thought about this. I believe in one roof principle. That is, what I mean by this is that I believe in having a network like the Global Privacy Assembly, which is really the overarching, the lead a network which actually regroups all networks across the world and come together and make some harmonization possible through networks, and that idea of convergence. I believe the GPA should really look into this aspect. They have been, I know, as part of it, we've been having these ideas in mind and trying to put some foundational blocks, but we are still, we need to innovate a little bit more in this aspect. We need to bring all networks together and not having, as I said, competitive networks, but together, networks working together to be able to achieve one purpose. This is, I think, also my point of view. And lastly, as you know, capacity, resources are lacking at all levels. So if we have networks with, you know, right frameworks, a right mandate, but we don't have the capacity, we don't have the funding, we don't have the resources. At national level, we are struggling. Now, believe, if a permanent secretariat is not well equipped at a level of a network, what is the, you know, efficiency of that network? So I would like to stop here, Asitu. I think I've covered a little bit of everything. Thanks.
Thank you very much, Rudisha. So if I'm going to summarize what you talked about, the key idea is to have an overarching network, a network of networks, and also, if this is not possible, at least to have networks that are properly funded and not under-resourced, and in general, that have a clear mandate in their articles of associations, and that work together rather than compete against one another. So thank you very much. And now I'll turn to Tamar and ask the same question to her. And if you could do it under 5 minutes, that'd be wonderful.
Sure. Those networks at some point offer different opportunities and great opportunities for experience sharing, research, so joint statements, guidelines, recommendations in response to common challenges. And we have some good practices, but of course we have to take into account that authorities newly established or with little resources, for them it's certainly hard to keep pace with all networks and developments. Therefore, we maybe should be thinking how to make this information engagement more accessible, more structured, interlinked. But let me also, because time is limited, address very important point for me. Besides the very important policy work carried out by those networks, there is a practical and more pragmatic, let's say, side of cooperation, which is mutual assistance, joint investigations, and enforcement. In those areas, much more can and needs to be done, I would say, and many of us have seen, for example, the statement that in April EDPB had made in relation to the stronger cooperation on cross-border cases, and other DPAs have also need the similar tools because enforcement, cross-border case handling is very problematic for many others. And when it comes to the possibilities, one of the possibilities I think we should be looking at is Article 17 of the Council of Europe Convention 108+, which specifically speaks about data protection network and obliges actually states to establish such network. And the mutual, let's say, cooperation includes joint investigations, joint cooperation, joint investigations and joint actions, mutual assistance in terms of information sharing. And I would say that a catalog of actions is not like restricted, it's quite exhaustive. Therefore, the proper and effective interpretation and implementation is key when we talk about Article 17. And currently, I know that the Council of Europe Data Protection Unit, which is also Secretariat for the committee, explores the opportunities how to, let's say, make this network as constructive as possible. And by the way, the Council of Europe has the supports 24/7 network under the Cybercrime Convention, which is known as Budapest Convention, which enables relevant bodies to have almost real-time exchange in terms of criminal offenses related to data and computer systems. The same type of networks are operated by the same Council of Europe with regard to terrorism prevention and safety of journalists. And I was wondering why data protection authorities cannot have a similar or even stronger tool. I believe that those pragmatic and more practical tools will not only be valuable for the current states of the convention, but for other countries like Gambia, Sudan, Sri Lanka, Vanuatu, and many others, Nigeria, like Ghana, and many others who strive to ensure compliance and with best standards, including Convention 108 Plus, and approached Council of Europe to get assistance in developing their data protection legal frameworks. There are a number of best practices, I would say, and pragmatic tools that can maximize the benefits of international cooperation, and specifically in the area of mutual assistance and joint actions for effective enforcement. Thank you.
Thank you very much, Tamar. And now moving to Joaquin with the same question. If you could make the answer very short, please.
Well, I have listening to my colleague, and so as you can see, there are many instruments in different data protection network in the legislation that facilitate the cooperation. I want to say that only there is apart from that, the next ingredients for collaboration is just the willing of the country to have collaboration. And in that case, I would like to share with you an example that for me is extraordinary good. We had a project with Ukrainian people. The project was stopped when the war started, and 2 weeks ago, they decided to resume the project. And now we are working on it. So, because they wanted to have this, even in the situation they have. For me, it was incredible. But they want to start the collaboration. So the legislation provides the instruments, the legislation provides the framework. As my colleague mentioned, in the GDPR, we have very strong and powerful instrument that is the mutual assistance and the joint operation that allow us to make an inspection together. One inspection in Spain can be made with inspector coming from other countries, and this has legal effect in the other countries, even in the inspection is made in Spain. So this is very powerful instrument. So just that we need is just the willing of the countries just to start the collaboration. I think this is very important.
Thank you very much. Thank you. And now I'm going to move on to the last question. I'm going to ask you all, if possible, to just give it 1 minute to answer so we can have some Q&A, the Q&A session. And the answer was partly provided as the answers to the previous questions. So the question is, what do you think a strong network of DPAs could bring in relation to the regulatory systems, i.e. lawmaking, regulations making, and also minimum standards, for example, data transfers. We talked about enforcement as well. So I will ask Tamar to start with.
When data flows has no boundaries, I think that the convergence between legal regimes and cooperation between DPAs is essential and perhaps the only way to address the common challenges, especially of cross-border in nature, and ensure that the protection is adequate or appropriate wherever data goes, and this is very important. And when we talk about the international minimum standards, including in the area of cross-border transfers, actually we have the instrument. Convention 108 was the landmark instrument since its adoption, and the only legally binding international treaty with global relevance, and the fact that 9 non-Council of Europe member states are parties to the convention, and many more are interested is also brings this global, let's say, dimension. And plus what is very important, the modernized convention is also possible instrument for global, let's say, regulatory convergence, as it sets the commonly acceptable principles and the rights. And you look at the different regional or international or national legal frameworks, we can definitely see that. And plus, this is the open document. Any country with complying data protection legal framework can request the invitation to accede. It is fully applicable with full width in the public sector, including law enforcement, national security, pandemic prevention, health, which is also an important dimension, and it's worth mentioning that it is very consistent and compatible with other data protection legal frameworks, in particular with GDPR, and I will just recall the negotiations, and EU played a very important role, and all European data protection authorities played a very important role in ensuring this consistency. So I think we have a starting point if we need a quick and legally sound tool, then of course we need a ratification, more ratifications from the parties. Right now there are 17 ratifications, 27 signatures that were not followed yet by ratification. And this will encourage also other countries and international organizations to join and build up step-by-step global protection for individuals. Thank you.
Thank you very much. And I move back to Joaquin with the same question.
Well, I have to say here, I think most of the things have been done have been said by my colleague. Well, that we try to find the converge, for example, in the framework of the American network, is because we have different legislation, obviously. So we try to find the convergence through for example, creating guidelines, producing guidelines in order to try to use the same criteria in the countries. As I mentioned before, we have produced a document with contractual clauses for international transfer. Now we have the initiative of the Colombian Data Protection Authority to start to work in a document about BCR, binding corporate rules. We are going to propose to the executive committee of the network to work in that topic in order to have a common criteria for all the Ibero-American countries. We have also the experience of in EU about the BCRs. So could be very interesting how to manage this and try to looking for the convergence between the scenario in America and the scenario we have in Europe. If we succeed in this, this will be very good for the commerce, for the companies. They don't have to adapt to one schema in America and different schema in Europe. If we succeed in this project, we can have, even if we don't have exactly the same model, a similar model in order to facilitate things. We are here to facilitate things to the companies and to the citizens, not to create barriers and to create silos. No? So this is the way we try to find the convergence.
Thank you very much, Joaquin. This is interesting to see how providing guidelines can be a starting point so that the laws can be adapted to the countries rather than just sending the Spanish law to be copied and pasted. So yes, I do see the input, and let us know how that goes for Colombia. And so now I'm going to move on to Valdemar from Brazil, and as well, if you could provide a very short 1-minute answer.
Well, I'm fully in agreement with Tamar and Joaquin. I think this is of utmost importance. Well, the data subject needs to be respected in one's own country, but also globally. This is what we sought for. So throughout these networks of authorities, this would be made and would be facilitated with joint investigations, with solutions such as, for instance, let's say Brazil has programs with startups and some smaller companies as they adjust themselves to the GDPR. Some of these solutions are already ongoing, so the sharing of these success stories is of great importance so that we can allow those who cannot afford as much resources to make them deliver the very best service to their population. We do have networks of authorities, but we need to broaden this. We need to bring them closer one to another. This will render protection on a global scale. This is of great importance. Yesterday we were talking about investigating companies that had undergone external processes. This sharing of information is of great importance in this stage. We will only benefit as we join forces amongst various authorities worldwide.
Thank you very much, Valdemar. And the last person that will speak today is going to be Rudisha. You talked about joining Convention 108 Plus in 2018. So in terms of the regulatory framework, this was a real adoption of the GDPR principles in Mauritius. And beyond that, what do you think the strong network of DPS could add to the regulatory framework and the standards in general, including for international transfers?
Yes, I would like to bring in the African perspective right now. I think it's very important to speak about it because that hasn't been covered at all. And I think we have to take into consideration the Malabo Data Protection and Cyber Security Convention adopted by the African Union Commission. This is one document that we have to speak about. We also have the African Personal Data Protection Guidelines. We have also the African Free Trade Continental trade agreements. We have the African Digital Single Market Project. And finally, we have the PRIDA project, which speaks about harmonization of data protection laws across Africa. These documents, I have been contributing a lot from the Mauritian perspective towards these guidelines. I think they are very important documents which are standard setting and actually incorporating many GDPR and Convention 108 principles as well. So they are very relevant for an international perspective as well. So I think the easing up of data localization requirements for making cross-border transfers possible and safe. This is also an issue that has been highly debated and is actually working in the right direction in Africa, because as you know, in Africa there are also many countries who have heavy or strict data localization requirements, given the country's resources and quality of the economy. So we appreciate all these, circumstances in these documents, and we give the right flavor to cross-border transfers, including safe and appropriate safeguards, along with what is happening in international arena. So I wanted to add this, Situ, I think that covers a little bit, because we've moved on from the GDPR now, from Convention 108. These are already established principles. Now we're looking forward to more, local context principles, which can make every geographical block feasible in terms of, pragmatic solutions. Thank you so much. Thank you.
Thank you very much, Rudisha. Thank you for giving us an overview of the different endeavors across the African continent. And now we are done with the questions. Just checking if we have David in Rwanda.
Yes.
Oh, good morning, David. How are you?
Good morning. It has been quite an insightful dialogue for us. Thank you so much.
So let me introduce you again. Sorry. So Colonel David Kanamugire is the CEO of the Rwandan National Cybersecurity Agency, which is also the supervisory authority for data protection. And this authority, Cybersecurity Authority, has set up a data protection office quite recently. So we will listen to David's observations and comments.
Thank you so much, and thank you, everyone. It's really been an opportunity for me personally, presenting one which recently established our data protection authority. So we're less than 6 months into existence. So it has been really important for us to know what the other data protection authorities are doing. It's been beneficial to learn about various networks, but I've listened keenly to how we could effectively collaborate. I think this is so vital for newly established authorities to learn the experience of how others have been established. I learned a lot from the discussions Georgia took, Brazil, and closer to us, a good example that Mauritius has been taking. So as a newly established authorities, one of the biggest challenges we face is both internally within a country. These are new sets of legislations that have not been existing, not only in Rwanda, but more in the region of East Africa and perhaps most of Africa. So data protection and privacy laws are quite new. And lots of businesses have been wondering what this is going to be impacting, how they are going to navigate, what implications they have on the existing business processes. So we are eager as a newly established data protection authority to learn how others have navigated this. I've picked a lot of notes, I've learned from a lot, and I think key take for us is that there exists a network of data protection authorities that is willing and ready to cooperate with newly established ones. So clearly, as Rwanda, will be reaching out to a lot of them. And if we come knocking on your doors, please open. We're glad from the case of Georgia, how they've helped others. So I think we'll be knocking too, but closer to home, we've also had the chance to start even a dialogue with Mauritius. And I've been privileged to have a meeting with Madam Rudisha. So we are really starting. So truly, these are important pieces of legislations that have fundamental impact to our economies and our people's rights and privacy. So we are learning. We're glad that we're part of this dialogue, and we'll continue really to learn about how effectively we can collaborate with these established institutions. So I thank you for the opportunity, and we'll keep to learn and look forward to your continued cooperation.
Thank you very much, David, for sharing your thoughts with us. Thank you. And looking here, do we have time for a Q&A? Or 5 minutes? Okay. Does anyone have a question in the audience? Could she be passed the mic? Oh. Try that, and I'll repeat your question. Go ahead.
Thank you. So my name is Laura Vasile. I'm currently studying in Leiden for my advanced master in law and digital technologies. And I've heard all of you sharing the opinions, and I'm very thankful for it. I'm very interested in the fact to what extent does information sharing cooperation would go to, and what do you think the limit should be, considering all the negative aspects that you can see it in? And is that competitive spirit being seen as a positive aspect with a targeted goal of involvement, or more of a self-made issue?
Do you want to answer this, Tamar?
Of course. As Rudisha also mentioned, there are some limitations when it comes to the offenses, and plus when we are the data protection authorities have to respect and protect first the personal data. Therefore, I mean, that's why when I talked about the Article 17 and interpretation in terms of the convention, that's why I said that the interpretation and implementation is very important, because it's not only one article, but the whole structure and procedures should, I believe, follow, that will set the scene and will determine like to which extent focal points will be able to exchange and share this information, because obviously there are many issues that should be considered.
Thank you very much. And we have time for just one last question. Does anyone have a question? No? So we are done. We are going to be around if you want to speak to any of us. And thank you very much for attending. And if you have a headset, is it possible for you to leave it on your chair, and we'll collect them? And thank you very much again, and might see you somewhere in the hall. Thank you.